I'm often asked, can I collect unemployment benefits if I've quit my job? Maybe. Let's review the law, the legal standard, and look at a particular example to answer that question. The law in Oregon is that if a worker were to quit their job without good cause, they don't get unemployment benefits. And the way good cause is looked at, there's a test. It says, would a reasonable and prudent person find the workplace, the situation, so grave that they would find there is no other option other than to quit the job? So what does that really look like? Looking at an example is helpful. This example is a recent case from the Oregon Court of Appeals. In this case, the employee suffered from mental health condition, which was aggravated by the conduct of her immediate supervisor. This employee spoke with human resources, other supervisors, and nothing changed about her work environment. When she finally gave her notice she was going to quit, human resources asked her, "Why are you quitting?" And she very clearly said, "I have tried to change the situation at work. My supervisor's behavior is not changing, and I'm left with no other option but to quit. My supervisor's actions are aggravating my mental health condition." Well, the Employment Appeals Board, the Employment Department, and the Administrative Law Judge all found that she did not have good cause for quitting her work because she had other options still available to her. She could have pursued alternative dispute resolution, mediation, for example, or she could have taken unpaid leave and just put some distance between herself and the workplace. The Court of Appeals did not agree with them. In its decision, the Court of Appeals explained two things. First, when we look at a reasonable person, we look at a reasonable person with the same characteristics as the claimant. So in this case, a reasonable person that also has a mental health condition. And would someone, reasonable and prudent, with a mental health condition, find this situation so grave that they're left with no other option than to quit? And second, what about being left with no other option? The Court of Appeals found that, in this case, this worker did everything she could do to try to communicate what was happening with her and change her circumstances. Any additional action on her part, dispute resolution or putting some distance between herself and work, untimed paid off, wasn't really going to change anything. And so because of these two factors, the Court of Appeals ruled in her favor. Now, your situation may be different. It may be more complex than this. I recommend that you speak with an attorney to learn your rights and the laws that apply in your case. To learn more about this issue and others, visit the Oregon State Bar's website at oregonstatebar.org.